All right, welcome everybody. I'm attorney Justin Randall with Hooper Law Office. And today our topic is about protecting loved ones from themselves. So that can mean a lot of different things depending on what's going on in your loved ones' lives, what concerns you have, and I'll touch on the kind of key important ones. But before going into our topic today, just a couple usual reminders that this is an interactive webinar, so if you have questions, please submit them to the Q&A function and I'll be able to see them come up. I'll go through and answer them as they come up, especially with this type of topic. It's one that I'm sure a lot of people have questions about or concerns about. Other than that, at the end of this webinar, you'll receive an email from us with a couple of things. We actually have a handout on protecting loved ones from themselves, sort of going through key points of what I'm going to talk about today. And then also some feedback forms that you can fill out that let us know if you have any topics you want to hear us talk about or feedback on the topics that we're talking about. But they also give you a place to let us know that if you'd like to come in and talk to one of the attorneys in our office, that we can reach out to you to set aside time to do so. Those initial consultations are complimentary. They're scheduled for about 2 hours, generally speaking. So it doesn't cost anybody to come in and talk to us initially, but we schedule them for the length of time that we do so we can really dive into detail and get to know the situation and hopefully help you diagnose what we need to at the end. So if you're interested in doing that after you hear me talk today, then please do so. Our topic next week is actually going to be on probate and trust settlement. So going through the key differences between the two, what needs to be done for both of those things, what those processes look like. And then the week after that will be our Green Bay public seminar at the Neville Public Museum. And if you want to register for either of those topics, the webinar next week or the Green Bay public seminar the following, you can do so at estateplannинglive.com. All right, I'm going to get started here. When we talk about protecting loved ones from themselves, there are sort of three, give or take, big reasons why you'd want to protect someone from themselves. Now, there's a lot of reasons why you'd want to protect someone from other people too, and things like lawsuits, creditors, divorce, all of those sorts of things. But when we're talking about protecting the beneficiary from things that they could do to harm themselves, we're talking about things like minor children, for example, or young adults, people who are over the age of 18 in particular, who may not be ready to handle the financial situation that they're inheriting or not have the experience to deal with that. So with minor children, when we're protecting minor kids, it's really more making sure that we have guardians named for those children. When you're naming guardians for your minor child, you have to do so in a will. So you can still use a trust for your estate plan. You can still use that to control the finances, but you can't name a guardian for children in a trust. That has to be done through your will for permanent guardians that are going to take over if both you and your spouse have passed away, or if you're a single parent and have passed away. The trust is more the financial side of things, if that's the component of the estate plan you're using. Now, you can also name temporary guardians in a financial power of attorney. So this can be a really important thing for you to do if you're concerned about, well, who has that authority to take over for me if I'm incapacitated and can't make decisions for my kids. So we will name those guardians in both places, both in somebody's will and in the financial power of attorney. It's just that the will is more permanent after somebody's passed away, and the financial power of attorney would be that temporary guardian if you're unable to act temporarily yourself due to an incapacity. Or if it's a permanent incapacity, then it would become a more permanent situation potentially. So good to name guardians in both of those documents so that during both of those situations, whether it's incapacity or death, that you have guardians that you would want nominated for your children. It's not that no guardians would be nominated for them if you didn't have them listed in those documents. It's just that you're not giving any sort of direction as to who you might want. And that can be very important because the courts take a lot of, or put a lot of weight rather on that nomination, because they want to make sure that they honor your wishes, that the people you've trusted to be in that position are given, a good chance at becoming those permanent guardians. But if you don't list them, it's much more open-ended. So Name those guardians if you have particular people that you would want to protect your kids, care for your kids if you're unable to. Now, minor children can't inherit property, they can't own property rather. So it has to be set up either for those minor children in a trust that doesn't terminate until a certain age, or they don't have access to until a certain age. Or you'll often hear like custodial accounts set up, or UTMA or UGMA accounts that they're also referred to as. It's Universal Transfer to Minors Act, or Universal Gifts to Minors Act accounts, and those are just set up so that that minor can't be in charge of those accounts because they can't own property until they are a legal adult at 18. So at 18, though, somebody could be in charge of an inheritance if you don't set other age restrictions on it. And that can be important to consider. What age would you consider your beneficiaries to be responsible adults? Obviously, as your kids get older, you're going to know more and more about whether or not a certain age is even old enough. But a lot of times we're naming 25, for example, as the age that somebody would have to be before they can be in charge of their inheritance. Now, that does not mean it can't be used for that minor or used for that young adult, rather, prior to age 25. It's just that they're not the ones making decisions about how to spend the money. There's a joke that was told to me by the founder of our firm. It's, I guess, maybe an old estate planning joke, if you will, that when you give a large sum of money to an 18-year-old, it's not a question of if they're going to go out and buy the Corvette. It's a matter of what color it's going to be when they buy that Corvette, right? And obviously that's a pretty sweeping statement, and not all 18-year-olds are the same, but it highlights a key concern that when you're 18, you can legally make those decisions for yourself, but it might not be the right fit because of a lack of experience or a lack of, background in those sorts of decisions, or maybe just they're not mature enough yet. So when you up the age at which someone can be in charge of their inheritance, you're more considering at what age do you feel comfortable, sort of as a starting point, having them make decisions over what they've inherited from you. And if it's even beyond that age, are there current concerns about responsibility that you're worried about? And again, it can be any age in theory. It can be as old as you want, or it could be as low as 18. But generally speaking, 25 is a good benchmark, just because of the studies out there on when somebody's impulse control is better developed, right, at 25. And I'm sure that that data is always changing too, of course, but the idea of it getting somebody at least through the college age, even if they don't go to college, that same sort of youth inexperience during those years is still applicable. So, knowing what age you would want minor children to be in charge of things, or your children to be in charge of things if they're even young adults, is important, because you can restrict that, and you can say what age that somebody has to be before they can make decisions over what they've received from you. And again, it can be used for them for their benefit prior to that. It's just that they're not the ones making that decision. It's a trustee, or the custodian on the account, right? Those sorts of things those sorts of roles rather are when somebody would be making decisions. And it could be their guardian, it could be the surviving parent, right? There's all these sorts of options that you have, but making sure that they're set up for success and not just handed a large sum of money when they have no experience dealing with it, it can be important. The other sort of youth component of that is that depending on how you have that wealth transferred to the children, will make it more or less public, potentially. If you have a large sum of wealth go to a young adult through a probate estate, well, that's potentially public record. And that's where you hear these horror stories of somebody coming up with this great investment idea they have for this person. I can help you really invest that money. And, I've got this great product, or I've got this great idea, right? And maybe that doesn't happen on a wide scale, but it's a risk. And so making sure that you have that wealth transfer in a way that maybe provides some more privacy, for example, through a trust, might be beneficial for them, just to protect that from the public eye and make sure that they're not approached by those individuals, or at least significantly decrease the risk of being approached by those individuals. We don't want people coming forward to them with the next best cryptocurrency, for example, which would be the one that I always comes to mind right now as, oh, I've got this great investment, give me all of that money. You know, you'll be a billionaire, that kind of thing. So, you know, youth is a really big one that we're protecting people from. And that's probably the most common thing that we're protecting people from, honestly, because everybody's young at some point. You know, we increasingly get less young, which I'm starting to realize myself, but we're all young at some point. We all have that inexperience. So everybody is going to have at some point in their life, their children are too young to handle things, whether that's due to actual legal age or due to, you know, just inexperience. What we also, though, look at protecting people from a lot of times is what happens when they're beyond an age where you would feel comfortable having somebody be in charge of the finances. What if they're 40, 45, 50, and you're concerned about their responsibility still? There are some individuals who, no matter how long you give it, no matter how old they become, they just can't manage those things. They've made bad decisions in the past. They may have other cognitive, you know, reasons that they're unable to manage those finances, whether it's, you know, potentially mental health issues, just, you know, early onset dementia, right? I mean, there can be all of those sorts of things where, hey, they're the age I would want somebody to be in charge, but they just can't handle this still. But also just the irresponsibility concern. You know, what if somebody's a spendthrift? They give a lot of, they just spend money as quickly as it comes in, right? If that's not how you would want them to spend money, or you're trying to protect them from any of those things that can happen even after a certain point in time, you can set it up so that they're never allowed to be in charge of that inheritance, that somebody else is always managing that for them. And that can really provide protection for them so that it's there for them to receive the benefit for a longer period of time. You know, it sometimes seems so restrictive when you're talking about not ever letting somebody be their own trustee, you know, even somebody in their 40s or 50s, right? But I view it as, in some ways, you know, an act of love to do that, because what you're trying to do by stopping them from spending all that money is to provide a more long-term benefit. It's not, again, it's not that it can't be used for them. It's not that it couldn't help them. It's just that rather than go out and buy that Ferrari, they're using it for housing. They're using it for retirement that they didn't otherwise save up for. I mean, it can be all of those things that people who don't have the responsible, you know, aren't responsible with their finances, who haven't been saving, who don't invest well, and just don't have the, you know, desire to do so. It can be important to protect them from that. I also have clients out there who say, well, that's, you know, their problem. That's their money at that point. They can do with it what they please. And that's a personal choice you're going to have to make. There are times where you know, clients decide that, but if you want to stop them from spending the money, you want to protect them from themselves in that sense, it's really important to name someone else to be in charge of it. And it's not a matter of just giving that person the money, by the way. You don't disinherit the person you don't trust to manage finances and then have the other sibling inherit their money instead and just say, oh, the purpose of that is for you to use it for your sibling. No, you want to make sure that it's still going to that child that maybe can't handle the finances, but just in a way that they are not in charge of it. So that would be like inheriting a trust fund potentially, where they're not allowed to be trustee, right? And so it still has to be used for their benefit, but it can't be used by them without the permission of a trustee or somebody okaying that. The risk of giving it to someone else instead to be used for that individual, and this comes up, by the way, a lot also in circumstances regarding children with supplemental or special needs too, where people don't want to leave the money directly to that person because of benefits purposes. But when you leave money to someone else as a beneficiary, that becomes their money. They're not under an obligation to use it for that person that you originally intended. They may have other issues themselves, like they get sued, they file for bankruptcy, they get divorced, right? That impacts that money that was meant to be used for someone else. So you still want to leave it for the benefit of that person directly. You just don't want that person in charge. And there are ways that estate planning attorneys can help you set that up so that that works and that it's protected for that purpose. But yeah, never leave it to someone else with the intention that they're going to use it for that other person, because there's just no guarantees with that. Even with the most trustworthy responsible people, things can still happen to those people too. One of the, this is a common concern people have. It's thankfully less common of an issue, but it does come up, and I've had it come up for clients' kids where it's a concern, right? Whether it was a past concern or an ongoing concern, that concern is substance abuse, addiction issues, right? And it doesn't have to just be substance abuse. It could be addiction to activities, like addiction to gambling, right? As an example. But people with addiction issues, if they're allowed to manage those finances directly that they've inherited from you, and those addiction issues are ongoing, that's obviously a concern of, well, what if they just go spend it on those things? And I don't know of too many people with those issues that are ongoing and not being treated, that they wouldn't go use it for those activities. So you want to make sure that you're protecting them from themselves, because that can cause real direct harm. That's more direct harm in a lot of ways than somebody who's just irresponsible with money or is young and makes bad investment decisions because they don't have experience, right? Substance abuse issues in particular cause direct harm physically to the person. And so making sure that they're not able to manage those finances directly, or they don't have access to it for that purpose so that they can use it for whatever they want, protects them physically too from those concerns. So you really want to make sure that if you have those concerns, that you have those addressed directly. And there's two ways that this can be addressed. There's prospectively addressing it, and then there's having something that triggers if it's a concern. So with prospectively doing it is the safest if you know it's a concern, right? If one of the first questions I ask people when they come in regarding kids and the people they're leaving things to is, do you have any concerns about how they manage finances, or do they have any health concerns? Is there a history of substance abuse, anything like that we should be aware of? Because if we know about it, we want to prospectively look at setting up that person's share of the estate so that they don't have access to it directly, so that someone else is managing it and not leaving it up to choice later on. You don't want to put that burden on a trustee of your trust or the personal representative of your will if you're uncertain about what that outlook is going to look like, and you don't know if that person is going to be aware of those concerns, the person you've nominated to be in those roles, right? The safest thing you can do is set it up in advance so that they're protected, that you're leaving them things in a way that they can't harm themselves with it, someone can't manipulate them, right? Those sorts of things. But it's also really important, even for the most responsible people in the world, the people you have none of those concerns about, that they're going to manage finances well if they get it. Right now they're very responsible, they're the person I trust with everything, there's no history of substance abuse, whatever the reasoning. If you trust them with it now, that doesn't mean that things can't still happen to that person where that's not a good fit anymore. The spendthrift issue is one that probably doesn't come up, change too much. If they're responsible now, it doesn't tend to change as much. But substance abuse can be something that people don't expect coming up. Mental health issues can be something that somebody doesn't expect to come up as an issue, or a cognitive decline due to early onset Alzheimer's or dementia or Parkinson's that leads to that situation. People don't often anticipate those things coming up if they're not already aware of them. But your estate plan should have terms in it, whether it's a will or a trust. It should have terms in it to make sure that you actually have a way for either your personal representative or of the will or the trustee of your trust, make sure that they have the ability and authority to trigger something, kind of turn on the switch of, now this person can't be in control of it. Almost maybe turning off the faucet is maybe a better way of putting it than turning on a switch, but they can control that more. And that what those terms tend to give them authority to do is, if in that trustee's discretion or that personal representative's discretion that they feel that that person isn't a good fit to be in charge of their own estate or their own inheritance rather, if they know of substance abuse concerns or are concerned enough about those substance abuse concerns that they don't think that person should manage their inheritance, they have the ability to trigger that. It's really important to know what your documents say, though, to know whether that's a possibility. I have seen plenty of wills without any sort of reference to that. Usually they're like 2 pages long and they basically say, here's the person in charge, here's where I want things to go. but they mention nothing about unforeseen circumstances, about substance abuse concerns, youth, um, mental health issues, or anything like that. And if it doesn't have those provisions in there, the options at that time are going to be incredibly limited. Another component of this, though, is also making sure that your estate is financially directed properly to ensure that those triggering provisions can actually work. So what I mean by that is a lot of people will have things payable on death or transfer on death directly to the beneficiaries that they want to inherit. In an ideal world where nobody ever has any issues, nobody has any concerns that come up for them, as long as none of that happens and you can guarantee that none of that happens, I'm sure, inheriting through a payable on death or transfer on death works okay for those people. But the concern is not that, what we have right now. We don't know, and we can never predict what's coming up in the future. So leaving those assets directly to the individual, kind of superseding someone's will or going around a trust that they have and leaving it directly to them through a payable on death or transfer on death provides absolutely no protection from those unforeseen circumstances, whether that's a divorce, whether that's a creditor concern, or a substance abuse concern or mental health, crisis, right? Leaving that money to them directly without funneling through a trust first or without funneling through someone's probate estate, and going in accordance with the terms of their will or trust that they've had drafted, provides no protection for those sorts of things. And that's because payable on death and transfer on death designations are tools to use. They're tools to use in coordination with someone's estate plan. They are not an estate plan. They don't deal with those sorts of concerns. And that is probably one of the most common reasons, though, that somebody runs into issues down the road, because they aren't able to trigger some sort of protection for the beneficiary. They can't control those funds because it just went directly to them. And this is obviously never somebody's intent. They're never intending for this to happen. They're looking for the easiest, simplest, most direct way for these funds to get from point A to point B. And in theory, that's all beneficiary designations really are, as a vehicle to get something from point A to point B. They were never intended to be anything more than that. So you need to make sure, if your will or your trust has protection for beneficiaries from themselves, from irresponsibility, from creditor concerns that they've created, right, spendthrift issues, from youth, from substance abuse or mental health concerns, make sure that you work with your estate planning attorney to direct those assets properly, either making sure that they are going to be subject through the terms of the will, which would require them to go through probate potentially, or making sure that if you have a trust directing things, that things are actually funneling through the trust. The whole point is to make sure that you want options, right? You want to make sure you have the option to protect those people if it comes up. And it's a lot like any sort of insurance that we all have. We have car insurance, homeowners insurance, health insurance, right? We don't know if those issues are going to be a problem, but we have insurance so that we're covered if they do. You can't retroactively put it in place. You need to make sure that they're in place prospectively, or the options are there prospectively, because you're not going to have that same way to protect it later on, especially if someone is unwilling to work with the personal representative of the estate or the trustee of your trust to do so. So you need to make sure that you've done that planning, you've worked with someone to make sure that that is what's going to happen, and that you're not leaving it up to chance. Otherwise, there's not much you can do at that point, like I said. To give you an example of the substance abuse concern in particular, we often use this as an example when we're talking about Medicaid planning for people, but it applies specifically to this situation as well. A family transitioned the home to the kids and gifted it to their 4 kids. In anticipation of needing care, they were trying to get it off, protected from Medicaid availability. And I won't go into too much detail on why that's a bad idea, but it is a bad idea, just to summarize it, to do that type of gifting. But where the issue came up is 2 of the 4 kids passed away before they were, the parents themselves passed away, right? So one of the daughters, their share went down to a son-in-law, because that's what her estate planning said, and she owned that quarter of the home. But where the substance abuse issue came in is their other child passed away and was a single parent, left everything to their grandson or the child's son, who at the time when they initially transferred the home over to the kids was 5 years old. So, well, there's a youth issue right there, of course, but what happened is this was 20 years later now that he inherited this quarter of the home and it was time to sell the home. He at age, his mid-20s had a pretty significant substance abuse concern and was a risk to himself because of that substance abuse concern. And the family wanted to work with us to find a way so that he was unable to access those funds. They didn't want him to not be available for his benefit. They just didn't want him to have control over it because they were concerned about what he would do with it and what he would very likely do with it. The problem, though, is because he owned those funds and it didn't funnel through a trust or it didn't go through someone's probate estate and wasn't in accordance with somebody's will or trust that had protection for those types of concerns, there's very little that they could do without his permission. And there's not very many people that are in the midst of an addiction crisis that would willingly give it up. I'm sure it has happened, but it's very, very unlikely. So it's very important to make sure that you have those protections in place in advance. I know I've said that a couple of times, but I can't stress it enough. So I'm not seeing any questions right now, but if any questions come up that you didn't feel comfortable asking as part of this, you can always reach out to us. And I would highly encourage, if you have these concerns for your kids or your estate and you just want to protect people, that you fill out that feedback form that you'll receive from us that lets us know to reach out to you to set aside time to talk. Again, that is a complimentary initial consultation. We schedule them for about 2 hours. But if you're interested in our topic next week, which is going on probate and trust settlement, which we'll actually talk a little bit about some of what I talked about today, and like wills and trusts, about how those work. Please feel free to sign up for that. And then if you really want to listen to us talk more in depth on wills and trusts, attend our Green Bay public seminar at the Neville Public Museum on the following Wednesday, so 2 weeks from now. And you can sign up for either of those on estateplanninglive.com. But I guess I don't see any questions still, so I will let you guys go, and I